those topics, those issues that feature in people's, everyday family and matrimonial lives, and just so that you are educated in the eventuality of any of such scenarios in your life, and you are better equipped to handle them with the hindsight of, legal implications of your choices. And tonight, what we will be discussing, or what I'll be revealing to you, are 7 types of child custody orders that the court may make, and the implications of any of those orders. And this is because anytime there is, a divide in a marriage, anytime that there is a rift between a couple and they decide to go their separate ways, whether temporarily or permanently, oftentimes the fate of the children of that marriage, where children are involved, becomes an issue. And since the both of them cannot tear the children into two, the court must have to make a pronouncement, or the parties must have to decide on the best form of custody that suits their circumstances. So it is not just enough to say that you're settling custody or you're discussing custody. It is important that that custody is defined, because it's not just one form of custody that is out there. So, and in this arriving at any form of custody, whether privately settled by the parties, because yes, parties can decide between themselves and adopt, resolve on a custody type, they can also leave it to the court in its wisdom to pronounce on the kind of, custody that the parties will have. So whether it is judicially arrived by the powers of the court, or the parties, settle that between themselves, they need to define the kind of custody that they are arriving at, or that is going to be applied in the circumstance. So, and tonight we will be starting with the first on my list being physical custody of the child or the children. And this is because whoever it is that has custody, the most primary, the most elementary consideration will be where that child will stay, because the child is a physical being. So the child will have to be in a place. The child cannot be torn into parts. That child has to be in a place. So where will that place be? Who is going to have the physical custody of the child? Who will the child live their day-to-day lives with? In which residence will that child live? Will the child live with the father or the mother or any other person? That is the physical custody of that child. The person who will cater for the child's day-to-day needs. The person who will supervise that child, who will nurture the child's daily needs. The person who will, groom the child day by day. That is the person who will have the child's physical custody. And of course, what it means is that anybody who the court has awarded a physical custody of a child will be the person who will take care of that child, who that child will live with. I'm not necessarily talking about the person who will be making provision, as it were, but even where another person is making the provision, it means it is this person who has the physical custody that will be administering that provision to the child. So he or she will have to be the one that will tend to the child's needs daily, whether they are spiritual needs, they are moral needs, they are nutritional needs, they are medical needs, whatever those needs are, educational needs, that person will supervise to ensure that those needs are met day by day, because that is the person in physical custody. Of course, there are times when physical custody may not just be with one person, but at least you understand what I mean when I talk about physical custody. So whether it is with one person or it is with two or multiple people, one of the forms of custody that the court may pronounce will be the physical custody of the child. And it is critical because that child will not be left unattended. So somebody has to take care of the child's physical custody. And that is that. Then the next other form of custody that the court may award will be a legal custody. And you'll be wondering, does that mean that the physical custody is illegal? No, that's not what it means. By saying a legal custody, what the court will mean by that will be the person who, decides, who takes the important decisions in the child's life. So it is possible, for example, that the child's physical custody is with one person and the child's legal custody is with another person. That is possible. It's also possible that both parties will share both the physical custody and the legal custody. And a legal custody will then give the party that has been granted that legal custody the right to make the important decisions in the child's life. So where there are decisions to be made on maybe the child's educational path or options, it is the person with the legal custody that will make that decision. Where there are decisions as to the form of health care that child will have to enjoy, it is the person with the legal custody that will make those decisions. Where there are decisions on maybe where the child will travel to, the kind of developmental opportunities that they may explore, the kind of spiritual nourishment they may be exposed to, and all of those, their orientation, cultural and otherwise, the person who has a legal custody will decide on those, even if he or she is not the one administering them. So it means that one person may have a physical custody, like I have said, and another may have a legal custody, or both parties may have legal and physical custody, or another person entirely may have legal custody, depending on the circumstances of each case. And like I have said many times, and almost all the time that I talk about matters that affect children, what the court will be looking at is the best interest of the child. The court is not interested in who is hurt or not between the parties. The court is not interested in what either of the parties want to satisfy their ego or to satisfy their status or to satisfy their rights or whatever. All the court is interested in is what is in the best interest of the child. That is priority. So if it is in the best interest of the child that the legal custody be granted to another party, the court will definitely do that. And I have explained to you the implications of a legal custody. Then the other form of custody we'll look at will be sole custody. So a sole custody, like the name implies, means that one person has custody of the child fully, both legal and physical. It means that that one person is the alpha and omega in deciding what is best for the child. Of course, this will usually happen in situations where the court perceives that allowing the other party any custodial rights to the child may harm the child's best interest. Maybe in cases where there are possible allegations of irresponsibility by the given parent, where there are cases of maybe child abuse or substance abuse or such things. That means that that person cannot have the best interest of that child at heart, or doesn't have the capacity to have the child's best interest at heart, such considerations can make the court grant one of the parties or some person sole custody of a child. And of course, in doing that, it can also be because of some of the conflicts that usually arise, maybe where both parents have shown, or it has been seen, that they are not able to effectively co-parent, and foisting a co-parenting situation on them may undermine the interest of the child, may hurt the child's best interest. Those kind of considerations may make the court award a sole custody to a parent. So I've mentioned physical custody, legal custody, and sole custody. Then the court can also make a pronouncement on joint custody, or what you call shared custody. So earlier I had said that whether physical custody or legal custody, either of them or both of them can be joint or can be sole. It is possible that the court will grant one person either of those forms of custody, which makes it a sole custody, or the court may grant both parties that custody, which means it becomes a shared custody or a joint custody. And where a joint custody arises, it does not mean that both parties must continue to live in one house so that both of them will have custody over that child. No, that's not what it means. It means that that child will enjoy, a fairly equal access, or, both of them will enjoy fairly equal custodial rights over the child. So for some days or for some months or in certain periods, the child will be in house A with party A, and in other times the child will be in house B with party B. And it also means that both of them will have to, devise an effective co-parenting, agreement or understanding that will help them prioritize the interest of the children, so that they effectively communicate well and they effectively administer parenting care for the children. So when the children is in house A, assuming the child has medical needs or nutritional needs, it is taken care of. And when the child goes over to house B, party B continues from where party A stopped, and they continue to alternate in that wise. It also means that both of them will have to, communicate effectively to be able to reach decisions on matters that affect the child. So joint custody or shared custody means that though both of them are not living in the same physical house, the child alternates between party A's house and party B's house, and both of them co-parent, both of them communicate effectively to administer care and nurture and maintenance for the child or the children, and also effectively take decisions on matters that affect them for their best interest. Then it can also be a split custody. Now, for a split custody, what we usually find is that maybe some cases where there are children of mixed gender, sometimes you may find that the court will say that the boy or the girl will go to the male parent, or the girl or the boy will go to the other parent, maybe sharing them across gender lines or across other lines of other considerations. It is possible that maybe the child that has a special need goes to the parent who is best able to administer the peculiar needs of that child, or the child that is better bonded with the parent is, assigned to be in the custody of that parent. Unfortunately, where split custody happens, one of the dangers, one of the things you'll find is that it inadvertently affects the children's opportunity to bond as siblings. These children may end up being raised in, with different orientations, different backgrounds, and all of those. Being that, child A or child B is with that parent and the other one is with the other parent. So, but there are cases where a split custody may be ordered. But then again, like I had said, all the court focuses on, in fact, once the matter of a child is tabled before any court of law, the priority consideration, the lens that the court will immediately wear, is the lens of the best interest of that child. And if a split custody is perceived to not augur well for the welfare of the child, for the well-being of the child, for the wholesome development of that child, including their, ability or opportunity to bond with their siblings, particularly during the delicate formative years, the court will not make that order. But then again, each circumstance varies, and the court will weigh those in arriving a decision. Then, of course, there is what we call an interim custody order. That simply means an order that is granted temporarily. And this will usually happen where a matter is still before the court and parties are already separated, and the court needs to make a pronouncement as to where the child or children will be pending the resolution of the matter. So the children are not going to hang in the air until the court makes a final pronouncement on that matter, right? The children have to be somewhere. So they may have to be with party A or B, or even a neutral party. So what it then means is that an order made by court for the care, for the custody, for the well-being of those children, pending the determination of the full case, pending when it makes its final judgment in the matter, becomes an interim order. So it is an interim custodial order. So when we say an interim custody of a child, it means that the party who has been granted that custody keeps custody of that child for the period, whether a defined period or a period until the matter is fully determined. So that is what an interim custody means as it pertains to children. And of course, it's one of the orders a court can make. And that is essentially to ensure that the needs of the child are not left unattended just because their parents are before the court, trying to resolve their dispute. So the court must ensure that the children are well taken care of, even while that dispute is still being, resolved before the court. And then the last on my list will be a third-party custody. And a third-party custody simply means, as the name implies, a custody of a child that is granted to another person who is not the father or the mother. And yes, a court has the powers to make that order. This can happen where both parents are perceived as being maybe unreasonable, not capable, suffer some lack of capacity, anything that hampers the best interest of the child. Maybe both of them, their lifestyles does not speak well for the well-being of the children, for the development of the children. It could be that they are abusing drugs or any other substance. It could be that their lifestyle is wayward, and it could be that they don't even have a modest accommodation for the children. It could be that their jobs or some other thing, their lifestyle does not afford them the time that they could invest in nurturing the children aright or taking care of the children. It could be some medical incapacitation or mental incapacitation. It could be for any of those kind of reasons. Where there is a compelling reason for the court not to grant custody of a child to either of its birth parents, the court can decide to award custody of that child to an extended family member or to another reasonable member of the public, depending on the wisdom of the court, as per the facts or the circumstances of each case. But yes, the court can actually grant custody of a child to a third party. It could also be cases where maybe a child has been taken care of by another person outside of its birth parents for extended period, and that child has truly bonded with this person and prefers to be with this person, feels safe with this person. It could be a grandparent, it could be an aunt, an uncle, it could be somebody else, it could even be a neighbor, it could be a caregiver from a charity home or somewhere. If that child has been tended by that person over time and the child prefers to be with that person, because sometimes the court actually considers the child's preferences, where the court is sure, where the court is convinced that child is able to make informed decision, the court can also consider the child's preference. So it could be any of those kind of situations, or where the environment of both parents is such that the child may be exposed to exploitations, particularly sexual and all those forms of psychological exploitations that are harmful to a child. So those are the situations where the court may decide to grant custody of a child to a party beyond its parents. So we've listed 7 kinds of custody orders that the court may award on matters concerning the children. And in any of this, what the court will focus on, what the court will prioritize, is what is best for the welfare, for the interest, for the well-being, for the development, wholesome development of the child. And once the court answers that question, the court will make an order that satisfies that best interest of the child, and not necessarily as a punishment or as a reward, to one party or the other. No, the court doesn't consider that at all. So, and of course, each of these forms of custody order have their implications, and I've mentioned some of them, and I've said that there are cases where granting a type of custody may not be best for the child, and where the court sees that is the case, the court will not make that award. And that parties can actually decide by themselves. The law permits for parties, in fact, the law encourages parties to discuss, mediate, negotiate, and arrive at some settlements that are acceptable to them. And where they make those resolutions, where they are able to reach those terms of settlement, the court will usually adopt it as its consent judgment in the matter. But where the decisions they have reached, the resolutions they have reached, are also perceived to not be good for the children, the court is not going to hand it to them just because they have decided or they have resolved or they have agreed. No. So if, for example, they decide that the children will stay in one home by themselves where nobody will be taking care of them, and that either of them will be visiting the children once in 2 weeks, and the court does not see that makes adequate provision for the care of the children, their nurture, the court will not accept that settlement. So things like that. But yes, parties can agree, and it is actually encouraged. If they're able to agree, the court will adopt what they have agreed and incorporate it into its judgment as what we call consent judgment, and it will then have the full backing of the law, for easy execution and enforcement. So I think that brings us to the end of the 7 types of custody orders that the courts may award in issues of child custody. Do you have any questions? Is there an experience you have that you'd like to share? Or is there a question, something I've said here that is not quite clear to you that you'd like for me to clarify? Or something that you were expecting to hear that you didn't hear that you'd like for me to talk about? Whatever your question is or comment, contribution, suggestion, whatever, feel free to drop it in the comment section wherever you're watching us from, whether you're on TikTok, Facebook, YouTube, Twitter, Instagram, wherever you are watching from, or you're listening to the podcast. Please feel free to drop your question, and I will be in the comment section engaging with you, responding to them, and acknowledging your comments. Thank you so much for joining me on tonight's episode of the Late Night Intercourse with Choma. As always, it has been the Zest family lawyer, Choma Onyenucheya Uko, bringing you this enlightening episode. And I'm looking forward to having you join me again, same time next week Thursday, for a fresh episode of the Late Night Intercourse, where we discuss issues within the family law spectrum. As always, I pray and hope that you thrive, just as your relationships, your marriages, your families thrive. All the best. Do enjoy a restful night. Good night. Bye-bye.